Good morning, Chief.
The chief's not on yet.
How are you?
I'm doing good, Commissioner. How about yourself?
You're still pipeline chief, right?
Yeah, I got it. We talked about that.
Yeah, you did. You doing all right?
Yeah, definitely. Let me close this down in my background. Sorry. Let's see here.
That's all right.
There you
I think
go.
it's just the two of us.
There's quite a few people logging in
No,
now.
there's more popping in. Yep,
Yeah, they're
yep,
coming like rabbits.
yep. I see Danielle,
Yeah.
Renee.
Good
Hello,
morning,
ladies.
Commissioner Bird.
Hello, Danielle. Good to hear your voice.
Good to hear yours too.
Morning,
Thank
Commissioner
you.
Bird.
Good morning, Renee. How you doing?
I'm doing well. How are you?
I'm good. Thanks for asking.
Good.
I'm enjoying a beautiful morning. What is it? 46 degrees and hardly any wind, which is unusual. So, too bad I'm sitting here.
It's freezing here in Santa Fe.
Yeah.
Overcast and windy. It's cold.
There was ice in the hose, the garden hose this morning. It took it a minute to pop loose. I was kind of surprised, but it's warmed up already.
I'm ready for some warm weather.
I like cold. You know, I wear a coat all the time. I can't take it off, so the cold doesn't bother me near as much. Good morning, Hans.
Good morning, Commissioner Bird.
How are you doing?
Doing good, doing good.
Yeah. Are you in that swank office today, or are you going to be in a little more plain New Mexico style office?
It'll look like I'm in the swank office.
You're going to be in the swank office?
Rest
All
assured,
right.
if I actually showed you the New Mexico office, no one would be as impressed.
Well, it is New Mexico. We might be.
Nothing but my dog sleeping on his bed, you know?
Oh, there you go. A nice, tranquil picture of a dog resting. You know, that's peaceful, especially in moments when you can feel the tension is rising. Maybe you pop that up there and people will relax a little bit.
Yeah, you know, I'll consider that. There might be a part of the agenda today where we get a little.
Right. You never know
So
when it's going
maybe
to
I'll
happen.
just pop that up. We'll test that theory. How's that?
My theory's always proven true. And you can't write any of that, Sarah.
Good morning, Commissioner.
Good morning. How are you?
I'm just fine. How are you doing?
I'm good. One of these days we'll actually meet.
Yes, definitely. Hopefully not.
We may be in our
before too
80s.
long.
And,
What's
yeah,
that?
hopefully. We may be in our 80s when that happens at this
Right?
rate, but you know.
Maybe so.
But maybe before I'm out of the commission, if we're lucky.
I hope so.
Yeah, me too. Good morning, Commissioner. You're still muted. There it is.
Good morning, Commissioner Byrd. How are you?
I'm good. How you been?
Hanging in. I'm vaccinated. So.
Oh, good. What for? Rabies?
This was the bird flu, spelled B-Y-R-D, that I was vaccinated against.
Well, let's hope it's an effective vaccine then.
I hope so too. Well, regardless, I feel a new sense of freedom.
Did you get both shots already?
Yeah.
You got them both. All right.
Got them both, passed my 14 days. I feel safe enough that I would even potentially visit your home.
Oh, yeah, go ahead.
I'm loving it though. You got that great background going and it's like you're Yahweh.
Right.
God just floating in front of the.
I'm not sure. I guess, I've got a lot of sunlight here, so I think that's why I'm not quite this pale. I get out more than it looks. Unlike Renee, I mean, that young lady is white. Look at her. Whew.
Who?
Renee Kepler.
Let's see.
No screen today.
No, it's just a little white image.
But there's Renee depriving us of her beauty.
That's right.
Oh, thank you, Commissioner Fishman and Bird. Thank you.
Mr. Chairman, good morning. This is Jason.
Hey, Jason, are you going to be manning the chair? Or are you going to be handing that over to Wayne, or how's that going to happen today?
I'm actually going to go ahead and get the commission through today, and we're going to allow Danielle to share her screen and go from agenda item to agenda item. But my involvement is going to be pretty limited. And then when we get to communications with Chief of Staff, obviously that would be with Wayne. Otherwise, I think next week, a new Zoom calendar invite will be shared with the commissioners and the PRC. So it allows the Chief of Staff's office to host the recurring meeting rather than it being tied to my account.
Okay. And, okay, so we're going to have limited opportunities for hazing the new guy, huh?
No, he's joined us. I mean, he's on the call. So
Okay.
whatever's the pleasure of the commission is the famous saying come from our
Morning, Mr. Chairman.
Good morning, Wayne. Are you ready to, we're going to be hard on you this morning. You're the new guy.
I think I'm as ready as I can be.
Oh, okay. Great to have you on board.
Thank you. Appreciate that, sir.
Good morning, everybody.
Morning, Joe.
Great to see you, Wayne.
Okay, one more minute for the public to catch up. It's Commissioner Hall. Are you on? Commissioner Vicente Aguilar, are you on?
She
yes,
is.
Mr. Chairman. Good morning.
Good morning.
Good morning.
I have a question for Hans.
Go for it, Yahweh.
That is neither your swank office or a dog sleeping in the background. What do you got going on there?
That is my dog taking in the scenic view of Mount Taylor.
Ah,
Yeah, I'm liking that.
yeah, it is pretty.
I thought a picture of him on a hike would be more appropriate than him sleeping.
Well, you know, sometimes what we're more accustomed to is our natural state.
That's true.
I'm sure he gets a lot of sleep. I know my
Yes, he
dog
does.
does. That's all she does. Until I'm trying to sleep, and then she just keeps waking me up.
Okay, we're gonna get underway here. And, you know, I'm promising Wayne that we're gonna haze him as much as possible on his first day, on his first meeting, excuse me. So Wayne, would you please say the Pledge of Allegiance for us?
I'd be happy to, Mr. Chairman. Good morning, Mr. Chairman and members of the commission. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
And the state. Or did I catch you?
Oh, Steve. What did you say, Steve?
Cynthia, you cover the state pledge for us.
Well, we shouldn't put him on a spot like that. I salute the flag of the state of New Mexico, the Zia symbol of perfect friendship among united cultures.
Thank you. Great teamwork.
That's right.
Consideration and approval of the agenda.
So moved.
So moved.
Oh, second.
Okay, we've got a motion and a second. Mike, would you call the roll?
Commissioner Fishman,
Aye.
Commissioner Hall,
Aye.
Commissioner Vicente Aguilar,
Aye.
Commissioner Maestas,
Aye.
Commissioner Byrd.
Aye.
The agenda is approved by a vote of 5-0.
Okay, introduction of special guests. Anything on the agenda here, Jason?
Mr. Chairman, Commissioners, good morning. No, we don't have anybody for today. Actually, I'm sorry. Yes, I want to give the floor over to Mr. John Reynolds.
Yeah. Good morning, Mr. Chair, and good morning, Commissioners. For the fourth time this year, I've got the pleasure of introducing a new employee with the Utility Division. And I understand I won't be able to complain about not enough resources, but this is all good news. The new person we have is Chuck Martinez. He has an education in regulatory matters. He has experience with the utility. He is going to join the Economics Bureau under Alicia's able supervision, and I would appreciate your welcoming him to the commission, and he can introduce himself as well. Thank you.
Hi, my name is Chuck Martinez. I'm pretty excited and looking forward to all the opportunities to serve the public and make a positive impact in New Mexico.
Welcome. Very nice to meet you, Chuck.
Nice to meet you all too.
Welcome aboard. We promise not to make your life a living hell. And, no, I think we've got a good group of teamwork, and you're lucky to be working with John Reynolds, who's, as you will find, just is about as high quality and high character human being as you'll ever run into. So
I'm looking forward to it.
So welcome aboard.
Wow.
Thank you.
Welcome, Chuck.
Thank you.
Thank you very much, Commissioners. I'm blushing now. Thank you.
Thanks, John.
I'm working hard to embarrass everybody today. And you guys are going to get me back. I know.
Yeah, you mostly just embarrass yourself.
Well, you know, a little dose of truth never hurts.
Yes, sir. I join you in that effort.
Okay. Public comment.
Mr. Chairman, we don't have anybody registered for public comment today. Thank you.
Okay, and we're on to consideration and approval of prior meeting minutes.
So moved.
So moved. Second.
Mike, would you take the roll?
Commissioner, to clarify, this is for approval of the minutes of the March 17th, 2021 open meeting. I'll take the roll. Commissioner Vicente Aguilar.
Aye.
Commissioner Hall.
Aye.
Commissioner Byrd.
Aye.
Commissioner Maestas.
Aye.
Commissioner Fishman.
Aye.
Commissioner, the minutes are approved by a vote of 5-0.
Okay, and we're on to item 1. It's the matter of the application of the City of Tucumcari Ambulance Service for reissuance of certificate number 02754 to provide ambulance service. And Hans, please take it away.
Thank you. Good morning, Chairman Fishman and fellow commissioners. At the April 14th open meeting, the commission took emergency action granting temporary authority to Tucumcari Ambulance Service as their current operating certificate was set to expire on April 16th. As this action was not previously posted on the agenda for the April 14th meeting, the action constitutes an error under the Open Meetings Act. The statute's Chapter 10, Article 15, however, does allow for a correction of errors by holding a prompt public meeting, affording the parties an opportunity to be present, and publicly voting on and ratifying the decision that was made. If I can get a motion to vote and ratify the decision that was made on April 14th, which granted Tucumcari Ambulance Service temporary authority, our letter to the Attorney General in this matter will indicate that we did indeed, in fact, correct the error at this meeting. So there is no potential order. The order was already made at the April 14th. We are simply just ratifying that decision so we can notify the Attorney General that we corrected our mistake.
So moved.
Second.
And Mike, would you please take the roll?
Commissioner Byrd.
Aye.
Commissioner Maestas.
Aye.
Commissioner Fishman.
Aye.
Commissioner Vicente Aguilar.
Aye.
And Commissioner Hall.
Aye.
Commissioners, the motion is approved by a vote of 5-0. I'm sorry, excuse me, the order is approved by a vote of 5-0.
Okay, on to item 2, docket 12 389 UT in the matter of petition of Q-Link Wireless for designation as an eligible telecommunications carrier for the limited purpose of providing lifeline service in the state of New Mexico. And Anthony, I see you're on. Please take it away.
Thank you, Mr. Chairman. And Mr. Hearing Examiner, you have permission to co-host. If you need to share your screen, feel free to do so. Thank you.
Thank you, Jason. With your indulgence, Mr. Chairman, Commissioners, I do have the order recommending dismissal of proceeding with prejudice before you that I'd like to put on screen, along with at least a couple of bench requests that, as you'll see in my presentation, bench requests, commission, as I treat them, commission orders, play a vital role in this case and my presentation, so I may present those as well. So I'm going to go ahead now and put the order recommending dismissal of prejudice with proceeding on screen. Hopefully you see it now.
Yes, I see it.
Thank you, sir. This order recommending dismissal of proceeding in case 12-00389 UT is effectively a recommended decision. I styled it as I have in the past when dealing with motions to withdraw pleadings or withdraw from cases. In this case, a motion to withdraw petition filed by Q-Link on November 22, 2019. Rather than call it a recommended decision, although we treat it as such, and you'll hear me and perhaps Associate General Counsel Russell Fisk call it an RD, or recommended decision. The reason for that is it's postured as a decision, and in this case, a decision on the merits, because it comes before a hearing on the merits has been held, as you see on page 2 there. A recommended decision issued and final order entered. Therefore, the commission's procedural rules dictate that this be treated pursuant to Rule 12B, which is quoted there, the operative part of Rule 12B, or all of it on page 2. So with this order or decision, it's based on Q-Link's, as I mentioned, motion to withdraw. They request, as you see on page 1, a motion to withdraw the amended petition, quote unquote, without prejudice to its right to file a new petition in the future. Obviously, in the title, I give my decision away because I'm recommending that the commission dismiss the case with prejudice for the reasons that follow and are set out in the recommended decision. I'd also note that obviously the docket number for this case is a 2012 vintage, obviously an old vintage. Part of the decision sets out in detail why that is so. But I'd also mention that this type of proceeding is based on, let me go back to page 1, Q-Link's amended petition filed in September 2017 for approval to establish eligibility to receive support from the federal USF fund to provide lifeline-only service to qualifying consumers in New Mexico. This is not the type of ETC petition that I understand the commissioners have been seeing recently, where more local companies are seeking designation to establish eligibility for the rural broadband fund. This is a species of entirely different, this case, ETC proceedings involving mobile virtual network operators, MVNOs, or resellers of major carrier telecommunication service, carriers like Verizon and AT&T, Sprint, T-Mobile, that are foreign telecommunications companies that may be based in Florida, as in the case of Q-Link, or Kansas, or Iowa, or even California. Right now, I'll let you know that there is one other pending MVNO Lifeline ETC petition pending before me involving Sage Telecom or TrueConnect. These cases are typically more complex. They involve more issues. They have, in the case of Sage, several interveners. In this case, as you see on page 3 there, staff is the only other party to the case. As I note there, staff opposes the request to withdraw the amended petition without prejudice for grounds discussed at the end of my presentation. Also, regarding these lifeline petitions of the type in this case, typically these MVNOs have ETC designations applied for and perhaps approved in numerous jurisdictions, including 30 to 40 states, or ETC designations even in Puerto Rico or the US Virgin Islands. So that's, as I mentioned before, the bench requests play a key role here. I learned early on in these cases, even before Q-Link, that the bench requests would be important in part to learn about these foreign companies and their experience in other states. As you see, that plays a role here in this order. And also before the FCC and USEC, the Universal Service Administration Company, which is as you know, the FCC's contractor to oversee the Lifeline program with regard to issues involving fraud, waste, and abuse, and whether a company may have been cited, sanctioned, or called out for one way or another for violating FCC rules. So in this case, you'll see that I issued what is a pivotal first bench request on remand back in 2018 after the case was assigned to me. And it asks for, and it's an iterative process I've learned over the years, to ask more questions of the applicant regarding ETC designations in other states, decisions and material orders, to provide an ETC designation matrix, which I provided in this case an example. There's an ETC designation matrix that plays a role in this case. There is critically a duty to update and supplement as we go along based on things that happen in other cases, even including a matrix of consumer complaints, administrative actions in other states, which is absolutely critical here, you'll see, and also critical civil and criminal court matters involving QLink, its parent company, and executives and board members of the entity. So in any event, getting back to the decision, this case is complex procedurally as well because it involves two basically different proceedings. In the first proceeding, I issued a recommended decision in August 2014. And in that decision, I recommended that the commission approve the designation of QLink to provide both basic and tribal lifeline service. However, on the very eve of the open meeting, when I was set to present the RD in the RD in the original case in October 2014, on October 2014 to be precise, we learned from counsel for staff, I learned on the eve of my presentation that QLink's CEO and sole witness in this case, in both cases, Isa Assad, had been charged in Broward County, Florida with what had been variously described at the time in news reports as first-degree murder or capital homicide, allegedly perpetrated in July 2014. When the commission heard that, the commission tabled the matter, took it off the agenda. And as you see highlighted there in orange, from that pivotal day forward, that's a hinge point, because from that day forward, this case sat completely idle for over 2.5 years, nearly 3 years, until we heard from QLink again on March 10, 2017, with the filing of a pleading it called a motion to supplement record and approve the recommended decision. Now, I need to pause for a second and say that I emphasized on page 4 there that basically that pleading requested after a 2 year, and bear this in mind as I go through the discussion about what actually happened and what was learned about what QLink was demanding in that pleading. QLink was demanding in that pleading that despite the considerable passage of time, considerable changes in FCC law on lifeline service, that the commission proceed solely on the basis of the material attached to the March 10, 2017 motion, and a truncated review process to issue a decision and final order adopting what the corrected recommended decision, the
Mr. Chair,
August
could I-
2014 recommended decision. And I'm sorry, I'll pause there. I thought
You're
I
muted,
heard
Cynthia.
Commissioner Hall.
Commissioner Hall, go ahead.
You're on mute, Cynthia.
Yes. Well, my question is, why did we not just dismiss the case? Don't we do that sometimes? I mean, 2.5 years is not the longest time that case has languished, but do we not have that ability to just, dismiss something for lack of prosecution, like in court?
Madam Chair, Commissioner Hall, yes, in that case, I believe, and I don't want to speak for the general counsel, but my thinking in this regard is that what would have happened is would be a dismissal, and in that case, it would have been without prejudice.
Mhm.
But yes, I believe the commission has the inherent authority to dismiss a case that sat idle for that long.
Yeah. Just curious, that's all. Please
Good
proceed.
question.
Yeah.
Thank you. Now, bear with me. I'm not going to go through everything in the order in this decision, I promise. But it is a winding, complicated factual scenario that took a lot of pieces to the puzzle that are put together carefully in this decision. Now, again, bearing in mind what Q-Link was requesting that happened in the case is that you basically simply look at the paper record and issue a final order approving. There was no mention in the motion, the March 10, 2017 motion, about why there had been a 3-year gap in the record. The bare allusion, the only really mention in there, and it's just a hint basically of the logically causative factor for Q-Link's otherwise unexplained pause in seeking any form of action in this case, whether requesting dismissal, holding it in abeyance, or as eventually conceived, demanding action on the recommended decision, was a cryptic note in the footnote that the case was removed from the agenda as a result of news reports about a criminal matter infecting a Q-Link executive. That Q-Link executive was the sole stockholder in reality, managing member of Q-Link's parent, Quadrant Holdings, a private, closely held Delaware LLC. And the Q-Link executive was the only witness in the case before and after, and is Q-Link's controlling manager. Now, it's accurately reflected there that the matter was ultimately adjudicated as culpable negligence, a misdemeanor as a sentence with probation. But I think that for reasons I'll explain and are highlighted on the next page there, it's important to set out what the matter was about. I'm not going to go into detail about the very tragic, horrific circumstances. They're there on the pages that follow. But I should emphasize before I even mention that as the decision is structured, and as I set out here, the factual details and outcome of the criminal matter that happened in 2014 in Florida are not relevant to my recognition or disposition of this proceeding, nor in all fairness, considering the totality of facts and circumstances, should that grim matter be dispositive or a persuasive factor. However, because Q-Link tried in this case clearly to downplay the criminal matter as affecting some unnamed Q-Link executive, and tried to conceal the matter from at least one other state commission, as you see there in footnote 16 and footnote 113, that being the California Public Utilities Commission, in proceedings, Lifeline application proceedings before that commission, and also because staff had quite graphically described, as I highlight there in footnote 17, what the matter was about. I thought that that for the benefit of the record and the commission's fuller understanding of Q-Link's demonstrable pattern of providing evasive, incomplete, misleading, and ultimately untrustworthy responses to bench requests in this proceeding, and relatedly, again, remember, proceedings in other states, in analogous circumstances before at least 2 other state commissions, which in my opinion establish, as you'll see in findings, a modus operandi of commissions that take their oversight responsibilities particularly seriously, that the criminal matter should be described consistent with information gleaned from publicly available court documents. Now, those documents are
Mr. Chair,
attached.
sorry, I just want to ask one more question.
Go
Yes,
ahead,
please.
Commissioner Hall.
Okay, just to be clear, Anthony, you were saying that the facts themselves of the offense are not relevant to your decision or our decision here today, but you believe that we should disclose it fully because the effort to minimize incredibly, very much the charges and the facts and circumstances associated with the charges in front of our jurisdiction and at least 2 other state jurisdictions indicates that the applicant doesn't take seriously enough his obligations under our oversight jurisdiction. Is that right?
Mr. Chairman, Commissioner Hall, that's
What? That's
I'm
what?
sorry, I was hearing an echo.
Oh,
Somebody, well, the echo went away now. That's accurately and well and cogently summarized, but you'll see, and I've highlighted, yes, but that it's a pattern of evasiveness, providing misleading and quite frankly, false and misleading answers, as you'll see. Look out for a smoking gun because I'm going to show you one.
okay, fine, thank you.
Here. But so Appendix A those are Broward County 17th Judicial District Circuit Court documents. Now, and I should also mention that I showed you that first bench request on remand issued in 2018. Later on, one of the violations of a bench request order was, and here I'm veering off track a little bit, but I think it's important. You recall that in the first bench request on remand, I asked for all civil and criminal matters involving the company and its principals and other, wherever that might happen. And one of the things that in answering the first bench request order on remand in 2018, Q-Link limited its response to 2 years of civil and criminal matters. And that's something that staff called out and said, wait a minute, that's not what the hearing examiner asked for. The hearing examiner asked for all. So that's an incomplete response. Well, of course, when you limit it to 2 years from 2018 back to 2016, you're not going to pick up what's in Appendix A. So even there, that is completely fair game. It's something I asked for. that Q-Link didn't respond. And that is one of the more minor, believe it or not, minor violations of bench request orders. So anyway, regarding the criminal matter, it's described there. It happened on the afternoon of July 5, 2014, apparently right outside Q-Link's offices, headquarters in Dania, D-A-N-A-I-A, Florida. It involved a dispute between Mr. Assad, who driving his Mercedes automobile for one reason or another, and I don't make a finding on, obviously it's not important, ran over. It's not important to the discussion here, and it's quite frankly, it makes me nauseous to talk about it. But
Anthony, this is Commissioner Fishman. I'm going to just quick ask a couple of questions because I think we can move this along a little more quickly. So first of all, I want to ask commissioners, have all of you read the decision? Has anyone not read it? Okay.
It was too interesting not to read.
Yeah, I know. It's like a supermarket tabloid.
Right.
I'm wondering if we could, without in any way impairing the record, Anthony, just kind of list all the, quickly, all the areas where the applicant was less than honest and what led you to this decision with prejudice. Because I'm thinking we're getting into a lot of detail that probably commissioners are feeling they probably know already, and we're fairly comfortable with the general theme of where you're headed. And I'm doing this because part of this is because I know that Commissioner Maestas has to leave at 11, and I want to be sure we get all our business done in time. So I have to own up to the fact that's pushing me along a little here.
Yeah, and Mr. Chairman, commissioners, in part because of the difficulty in presenting a decision like this, I was hoping that I would elicit a question, something like that, where I would not actually present, and I would ask you if you had questions. And so, with that very helpful guidance, I'll tell you what I was hoping would happen here, which is precisely this. But not knowing that, otherwise, I'm just going to have to try and give you the detail that I think might be pertinent. So thank you very much. Now, so I highlighted there when the case was remanded to me. By that time in 2014, the California Public Utilities Commission had already denied Q-Link's lifeline designation. And so the commission asked me to consider that and other issues. So after the case was remanded to me, that's what I did. Now, I get to the discussion and the analysis. And here, what I do is I look at the grounds or reasons why Q-Link, you have to find good cause to withdraw the petition and dismiss the case. In this case, they call it good cause to dismiss without prejudice. Well, they don't establish good cause without prejudice, but they don't even give really grounds. It's a series of complaints. The first complaint is against the commission, impugning the commission's objectivity and process. It's right there in what Q-Link says. It was unable to have its eligibility considered in a reasonable time frame and have its petition considered in an objective matter. After that, the complaints go against staff and myself. But there, the key point is that it actually discloses the pattern of concealment, evasion, and misrepresentation. The key point there is that it's showing the violation of bench request orders And the most telling one, I have several there, but as you pointed out, you've read it, but the most egregious one in the smoking gun that I mentioned was I asked for all administrative proceedings, including writs. And you'll see there that as what Keeling did is it redefined the bench request to get around actually concealing something that I found where in violation of another violation. So it's like this case is complex. Like I said, it's like a Russian nesting doll. There are violations within violations. And what I'm talking about here is Mr. Assad's response, sworn under penalty of perjury, according to his affidavit. He redefines formal and non-routine audits. I didn't ask for that. I asked for all audits. So, again, this is consistent with, well, we'll give you 2 years of documents back to 2016. So by defining defining the case that way, defining the bench request, what ends up happening is this audit is not disclosed. This is a USAC audit, and it shows violations of FCC rules, and it shows a monetary effect of $7,511 for one month of service in the state of Texas. Now, Keeling did reveal, oddly, another audit penalty, but that was $300 in Kansas. But by defining the bench request this way and then concealing this, that in my view is arguably disqualifying on its own, on the merits, disqualifying this particular violation. And so, but as I mentioned, the only reason I found out about that is later on, after addressing the California proceedings, and you'll see there that highlighted, talking about the pattern that I was talking about with Commissioner Hall, about where in the 2014 resolution of the California Public Utilities Commission, it found, among other things, that Keeling had provided contradictory and misleading statements, had shown a pattern of evasion, and had not disclosed information related to recent litigation against company principals. So I issued another bench request about just because the commission had highlighted this in its order designating the case back to me on remand, I asked a specific bench request regarding CPUC proceedings in January 2019. It's where I found that ultimately, as highlighted there in green, there was an advice letter number 10, where Keeling had renewed its request for designation as an ETC to provide wireless lifeline service in the state of California. Subsequently, moving forward after Keeling filed a motion to withdraw, I believe going back online to try and find out in the California what had been happening there. Again, I'm emphasizing that this is what the commission asked me to look at, to pay particular attention to. And we're going to look at what California does because, again, like some other states, California takes its oversight responsibilities seriously. It has professional staff, and therefore does. I found that in doing that due diligence, that you'll see there was a report, and I'm going to pull up another bench request here. This one, after I found this report online, this law firm showed that apparently that the commission had prepared to issue a draft resolution denying Q-Link designation in the state of California a second time. And that's this website from Cooper and White and Cooper that follows the CPUC meetings and has agenda items. There you'll see significant and held and withdrawn items is the Q-Link. This right here is that what I quote in the bench request. In any event, I found that what it looked like was the CPUC had denied Q-Link a second time, but I couldn't find anywhere in the record why that had happened. Well, apparently, after I issued that bench request that I just showed you, it turns out that Q-Link filed suit in California Superior Court, seeking, alleging that the CPUC had libeled Q-Link and its principal, and therefore went to court to block dissemination and even consideration of that resolution. And I should note that why it's called an advice letter and resolution, and this is important because it's Q-Link apparently has attempted to obfuscate even this, the procedure in California. Claim preclusion and issue preclusion does not attach to an advice, a tier 3 advice letter, apparently, under CPUC procedure. There's not a formal hearing. This is it's a step review, document review, a dialogue, I guess, with the applicant's attorneys. And one only gets to a hearing and a decision of the CPUC, and where the CPUC procedurals apply in a tier 4 proceeding. Lifeline proceedings in California are treated as tier 3 advice letter, like I guess akin to what we might have as an advice notice, where staff does a review of an advice notice and may issue a report or may not. So in that case, where there has not been a hearing and the administrative procedures are not attached, there hasn't been a formal hearing before a CPUC administrative law judge, and then a decision of the CPUC, it's a tier 3 proceeding, and therefore issue preclusion and claim preclusion don't apply. I think that should be very clear, and that's why it's called an advice letter. Anyway, it turns out in that resolution, as the complaint states, alleges, the CPUC, among other things, found that Mr. Assad had committed a felony. Well, that's libel per se in California, if it's false or not true. Turns out that what I think the California Commission was referring to, based on the staff report and resolution, I guess draft by the CPU staff there, was the conviction for culpable negligence based on the plea of culpable negligence, which is a misdemeanor under Florida law. So anyway, what happens is that advice letter 10 is withdrawn. That's why it doesn't show up in the CPUC records, but it's based on a lawsuit that was filed. But irrespective of that, as you'll note from the first bench request on remand, anytime you seek to withdraw in a petition in another state, obviously on just like circumstances like this, you have to report it to the commission in the litigation here within 5 days of that transpiring. Obviously, Q-Link didn't do that. And also, I mentioned the Russian nesting doll, that DPG, that USAC audit. The only reason I found out about that is because in response to that bench request regarding other state proceedings, it was there in a fully redacted resolution. That's what that was provided to me, was totally blacked out resolution. Buried in there, in that nesting egg, was the California Commission's concern over that audit. So I ordered an in-camera review under seal, but again, I don't think staff even was afforded the documents. I'm not sure, but I make the finding there that I didn't require staff to brief the issue. It ended up not being that important because what I'm talking about here is evasion and concealment, and it's a pervasive pattern that the California Commission found in 2014. That is shown, documented here, and is also shown in violation in another instance regarding the Oregon Commission proceedings that Q-Link also withdrew from and did not notify the commission that it withdrew from. And there again, what it does is says cryptically that it was order closed without order. Well, something triggered that closing, and it was this. This is a CPUC notice. This goes back to the commission saying that it was going to find a second time that it's not in the public interest to designate Q-Link as an ETC. This was not redacted. This was disseminated along with that draft resolution that the CPUC withdrew. It goes out to the telecommunications services in California. What I'm talking about now is Oregon. And in Oregon, what triggered the withdrawal was the notice of withdrawal by Q-Link. And that's what you have here. And again, it's establishing that modus operandi and that pervasive pattern. This withdrawal that I found in the docket, the Oregon docket, this notice of withdrawal, don't require a formal motion as procedures are different in different states. In Oregon, this reads like very remarkably like the diatribe that one sees in the motion to withdraw, if you read it carefully. And I just quote it, quite frankly, I just quote it in the order because it shows the pattern. And that I'm getting to that, scrolling to it right now. You see that in Appendix D, pages 3 through 6, where using very similar language to the litany of complaints regarding the process here. Being unhappy in Oregon, being apparently unhappy here, they sought to, Q-Link sought to withdraw. But in doing so, neglected twice, first to notify of the withdrawal, even though by that time, I knew enough to say, this time I'm asking for you in that bench request to describe proceedings in other states, not just the California proceeding, even though that's what advice letter number 10 dealt with, because I had already seen that there was a withdrawal in the docket. And at that time, in that matrix, Q-Link had that, it didn't address the Oregon proceeding. And so in the matrix that was provided in response to this last bench request regarding proceedings in other states, you get that cryptic note without disclosing the withdrawal and the circumstances around it, which remarkably appear, according to Q-Link's own notice of withdrawal, remarkably similar to the diatribe of complaints and unfounded attacks hurled at the commission and staff and even myself. Finally, in orange, it goes back to the pattern. The Illinois Commission also had a proceeding started by Q-Link in 2012. In May 2019, the Illinois Commission issued a decision, a thorough decision, denying Q-Link's request for ETC designation before the Illinois Commission. And you'll see there that I highlighted concerns that the ICC, the Illinois Commission, found regarding Q-Link's experience was hampered by Q-Link's behavior. The ICC was troubled by Q-Link's apparent attempts to obscure the facts or intentionally mislead the commission. This level of misdirection, I'm quoting, in an application makes the commission wary of Q-Link's response to possible future enforcement actions. And finally, such a persistent pattern by Q-Link shows an inability to provide accurate, consistent and reliable information, and is reason enough for the commission to deny Q-Link's request for ETC designation. Just as in some, it's reason enough for the commission here is that on this extensive record for the commission to reject and dismiss this proceeding with prejudice to Q-Link ever filing for ETC designation before this commission or its successor agency. And basically, that's what I have there in the findings, conclusions, and recommendation.
So Anthony, thank you for taking us thoroughly through it. It's a big step to dismiss with prejudice. So I understand you really need to build the case around it and build the facts. And it's a pretty impressive list of facts supporting the decision, I believe.
And all those facts were born of, I have to emphasize, they were born of the bench requests ordered by the commission, by me as your designee. So this is, there's no surprise here to anybody, if you follow me.
Any questions from commissioners at this point, or should I pass it on to Russell?
Mr. Chair, just pass it to Russell. I don't have any questions.
Okay, very good. Russell, go ahead.
Thank you, Mr. Chair. Commissioners, can you hear me?
Yes.
Since Anthony gave such a detailed presentation that really, I think, shows why this this matter should be dismissed with prejudice, I think I can go pretty quickly through my order, and I'll also briefly discuss Commissioner Maestas' proposed order, and he can discuss it as well, of course, if he wishes. As I noted in my memo, the proposed order would adopt Anthony's RD, essentially his order recommending dismissal of proceedings with prejudice. There are 4 exceptions, and I'll quickly discuss those. Now, as I noted in my memo, I used quite strong language in my proposed order, and Commissioner Maestas has used more sober language in his proposed order. But as I said in my email yesterday, both accomplish the same things and legally and with the same result. Both are perfectly reasonable orders for the commission to adopt. So let me get to I'll quickly discuss the exceptions because I know there is a time issue here. Okay, so Q-Link filed 4 exceptions to I'm going to call it the RD, the recommended decision. The first is that the RD is based upon information, quote, mischaracterized by the hearing examiner that Q-Link was denied the opportunity to address. Now, I'm not going to go into great detail on this because, as Anthony said, the issues with regard to the findings that underlie this recommended decision are findings about the company's behavior and conduct within this case. And it's a record of willful violations. It's a record of withholding of information, withholding of the most damaging information, withholding of information concerning other matters before other states, such as California, in which information was also withheld. So it's kind of a cycle of endless obfuscation, in my opinion. I use very strong language because I felt this is just extraordinarily bad behavior on the part of Q-Link. The second exception is that Q-Link argues that the RD considers, quote, extrajudicial information apparently obtained by the hearing examiner's independent factual investigation. This goes directly to the issue of a particular document that that Anthony describes in his RD that he found online from a law firm that indicated that there may have been a second denial by the CPUC, the California PUC, of a request for Lifeline ETC designation in California. It's presented in the exceptions as if this is something that the company Q-Link didn't have an opportunity to respond to within this proceeding, and as if it was being presented by Anthony for the purpose of the truth of the matter. It's asserted within the document found online, whereas Anthony made it crystal clear in his RD that one, that this document was not essential to the analysis and recommendations of his order. It was not presented for the truth of any of the matters stated or represented, but only to delineate the circumstances, I'm quoting now, through which the hearing examiner learned that Q-Link was concealing from the commission the withdrawal of advice letter number 10. And you heard Anthony discuss this to some extent. There were things brought up in the RD where he had to look just for contextual purposes at information to discover that information was being withheld because essentially Anthony was asking for this information, for such information from the applicant. It was withheld. And then now the applicant complains that the hearing examiner had to do some investigation to see what was being withheld. Well, how would he know what was being withheld if he wasn't receiving it from the applicant? So it's really, this exception is, I consider, an outrageous misrepresentation of what happened in the case below before the hearing examiner. And basically, I consider it a mudslinging false accusation against the hearing examiner. And it's really, as I said, part of a pattern. Exception 3, Q-Link argued that dismissal with prejudice is, quote, an extreme sanction that would deprive Q-Link of a property right without due process under the U.S. Constitution. The due process clause of the Constitution guarantees that neither life, liberty, nor property may be taken by the government without due process of law. Here, there are two problems with this argument. The first is that there was due process provided. There was an opportunity at every point in this proceeding for Q-Link to address its own deficiencies and its failures, its refusals, and I would say obstructionist behavior as it occurred within the case, and they didn't. And as I know in the language of my order, it's indefensible. It's not a surprise that Q-Link's strategy is to throw accusations against the hearing examiner, staff, et cetera, instead of trying to defend its own behavior, because its behavior in this matter has been indefensible, in my opinion. The other part of the analysis is not only has due process been provided, but there's no property right at issue here. The property right that's claimed by Q-Link is a property right in an ETC designation from this state that it has not received. There are some cases that have found that an individual or company may have a property right for due process purposes in a benefit that's been conferred by the government, such as welfare benefits, but only after they've been conferred. Here, nothing's been conferred to Q-Link. They have no property that can of any type that they could even claim as property that's protectable under the Constitution. And then finally, the fourth exception is that Q-Link argues that the commission lacks the statutory authority to impose dismissal with prejudice as a sanction. And they cite a case called Lujan versus City of Albuquerque. As you can see, and I think this is a very important part of this response, is that there are two bases on which the commission could issue this dismissal with prejudice. One, I believe this is such an extreme case of such repeated obstructionist behavior that an extreme sanction is warranted even under the case that's cited by the company. So as a sanction, I think it would stand. But it could also be considered, and my order would consider it, as actually a decision on the merits, because this is an attempted investigation, basically attempted investigation of this company that was repeatedly obstructed by the company, and a company that repeatedly is deceitful and obstructionist toward its the company the entity that will be regulating it is a company that cannot serve the public interest. And one of the findings that is required for issuance of an ETC designation under federal law is that it be in the public interest. And that's obviously a broad category. And here, I would say this is a sufficient record for the commission to find substantively that this is it would not be in the public interest to grant Q-Link the ETC designation based on the record of this case. And as I said, Commissioner Maestas' proposed order accomplishes the same ends, rejects the exceptions. It uses more sober language, but that still accomplishes the purposes of the order that I drafted. And so whichever one the commission wishes to adopt makes perfect sense to me. And with that, I'll take any questions.
Any questions from the commissioners?
Mr. Chairman?
Go ahead, Commissioner Maestas.
Yeah, I had a question just about Q-Link and the administrators of the Federal Lifeline program. If there is a multitude of states that are denying ETC designation for the intended purposes of Q-Link to seek Federal Lifeline, participation, why wouldn't USAC take action, or the FCC? Is there a higher level of oversight that could end this this trail of deceit and concealment? So, or is it just simply left to the states to study and benefit from other states' histories and experiences with Q-Link? Is this going to continue?
That's an excellent question. I'm going to see if Anthony, I don't know the answer to that. If the FCC ever just looks at the record of what the states have done and then, basically issues its own order saying we will consider this. Maybe Anthony, I don't know if you know the answer.
Well, Russell, Mr. Chairman, Commissioner Maestas, there are several, I think, still pending Q-Link petitions pending before the FCC for designation in states that don't do their own designation process. And I think many, at last check, there are other ETCs, other telecom companies like Q-Link that have those FCC jurisdictional petitions pending. Other states, like for instance, the state of Maryland, just issues this. In one case, they issued a single page letter to the applicant that didn't even mention the applicant's name, saying you're designated. So it's hard to say. It's left to the states basically to do their own processes. And as I indicated, some take that oversight process is much more rigorous, like this state has been traditionally, like California, like Illinois, like the state of Washington, perhaps. But then again, during this process, I think you'll find that Q-Link may have been designated in other states already. So it behooves the state to do what this commission and some of the other commissions do. Because what we're talking about, and I find here, we're talking about providing service. Once you get the designation, you're basically unregulated and you're serving a vulnerable population. This is not my words. It comes from a recent document that one of the national organizations submitted. So it behooves the states to maintain that rigorous oversight because it's very lucrative business, and it's serving a vulnerable and disadvantaged set of populations, including not only just the poor, but underserved and unserved communities like And in Mexico particularly, it's critical because we have a substantial tribal component as well. And ironically, if the commission had not known about what happened in Florida in 2014 and had taken my recommendation, QLEAK all this time would have been potentially serving unregulated, basically, tribal communities and other communities.
Just one more question. I had wondered if such an action as we're proposing can be extended to principles associated with QLink, and it's probably not in our best interests because of the associated risks. But obviously, at least the CEO, he is a common denominator in the MO of QLink, and is there any way to at least explore the commission's authority in extending such an action to CEOs like this one and prevent them from reformulating another subsidiary company and trying to seek the same kind of action, in this case, an ETC designation?
Oh, well, can I take first a stab at that? Commissioner Maestas, so I communicated with you yesterday about this, and Anthony gave me some information this morning, so some input on that, which I forwarded to Jonas. I don't know if you had a chance to listen, but our recommendation in OGC is not to do that. As you noted, in this case, Mr. Assad did not have notice that he might personally suffer a consequence as a result of this matter, and so we would that would be unlikely to be upheld if it were appealed. Also, a little feedback from somebody there. Also, as individually, there's not only the issue of notice to him as an individual being possibly suffering consequences. There's also the idea of where a commission order can go above and beyond a recommended decision in certain instances, but there's a chance that's taken there. I cited to you, Commissioner Maestas, the appeal by PNM of docket number 15261 UT before the Supreme Court. The commission was found to have violated the due process rights of PNM by issuing a final order in that rate case in which the commission disallowed all nuclear decommissioning costs associated with a particular Palo Verde, and the court said that went beyond the evidence that had been presented at the hearing, and the commissioners and the hearing examiner's recommended decision, such that it was something essentially almost like a new issue in the sense that it was so far beyond what had been previously discussed in the case that PNM hadn't had an opportunity to respond. So there are due process issues that would be raised in this case. With regard to holding individuals responsible for their actions, even when they're within a corporate entity, as I noted to you, we have had cases where we have done so. The commission has done so. I've handled 2 cases under the Public Utility Act in which individuals were held responsible for their actions as officers of water utilities. So that does happen, but in this case, you have an application by a company, and it's really the company that's at issue in terms of the result. Now, I believe we could take administrative notice of this record in a future case. Mr. Assad might apply under a different entity. I don't see any reason why we couldn't. The findings of this matter as insofar as they pertain to Mr. Assad. I hope that answers your question.
It does. Thank you. And I guess, Mr. Chair, since I have the floor, I just wanted to explain my order. As a co-author to these orders, I often look at the tone and tenor of them, and I realize that this situation is quite unique. I don't think I've ever encountered anything like this in my short, tenure with the commission. But I felt that parts of the order that was drafted was a bit subjective and inflammatory. And I know that this bad actor protested and questioned the objectivity of the commission, however baseless it was. And so I think that in our orders, that we ought to project objectivity and authority. And so my changes are just merely striking, some of these clauses and phrases and terms that that I felt was a bit too subjective. It doesn't diminish or change the record of decision. It doesn't strike any quotes from the recommended decision that were included in the order. So I would just say it's just a change in the tone of it. And I think we should always continue, and that's just my opinion, we should always continue to project objectivity and be authoritative in these, despite the nature of, I think, a lot of the violations that were cited in this. And I just want to close by commending Anthony. It was a very thorough record of decision. I think when the petitioner in this case is so upset because it was so thorough, and so I think we're benefiting from that as well. So so with that, Mr. Chair, I'd like to move to approve my order, my version of it.
Chair, excuse me for one moment. If I could.
Commissioner Hall, go ahead.
I'm sorry to interrupt, but
by the way, I'm sorry to interrupt. Please put yourselves on mute, folks. There is a lot of background noise that's not going away. So
Yeah,
if you're not talking, please put yourself on mute.
Yeah, Mr. Chair, that's coming from number 660-1143, I can tell. So that's probably whoever has that number should mute themselves or be muted.
Okay, go ahead, Commissioner Hall.
Okay, so I just want to say I also concur with Commissioner Maestas about editing the more subjective sounding language, and I appreciate the quality of his additions. But as we were sitting here today, I was thinking about the fact that we were having to parse information from other states' language that wasn't necessarily very revealing. And it occurred to me that what we have in our order is an opportunity to make specific the basis, our specific basis for our decision. And I wanted to propose two minor additions to the edited version that Commissioner Maestas provided us today. And I'm sorry, I just wrote it as we were sitting here because that aspect of our discussion just, really kind of struck me as something that might be helpful. And if I could just read the two things to you guys.
Sure.
One is in paragraph 4, which, as Commissioner Maestas has edited, well, they're both in that paragraph. The edited version reads, I'll read it that way. The commission this has to do with exception number 1, that Q-Link objects that the RD is based on information that mischaracterizes mischaracterizes their position. And it says, the commission rejects this exception. Q-Link had more than sufficient opportunity to respond to the hearing examiner's findings. The RD presents a record of Q-Link's repeated willful violations of the hearing examiner's order and a lack of good faith in Q-Link's participation in the proceeding. I would add, after lack of good faith, the phrase "and full disclosure." So therefore it would read, the RD presents a record of Q-Link's repeated willful violations of the order and a lack of good faith and full disclosure in Q-Link's participation in the proceedings. And then I would add one more sentence following what's in the text. The text reads, in the many years that this docket has been pending before the hearing examiner, Q-Link has never attempted to explain its behavior in these proceedings. And then I would propose that we insert this statement because I think it gives pretty clear notice to other states. It says, instead, Q-Link has sought to conceal important information relative to its adverse regulatory treatment in other states, specifically California, Texas, Oregon, Kansas, and Illinois, which casts strong doubt on Q-Link's trustworthiness to serve the public interest in compliance with our laws. Anybody mind that?
Anthony, were you raising your hand there?
Yeah.
I am, because, and I'm not interrupting Commissioner Hall, Mr. Chairman. I just wanted to note, it occurred to me that one of the other things that the CPUC got wrong is over the confidentiality dispute over the training manual in this state. The CPUC said in that advice, that resolution, that draft resolution, that the New Mexico Commission had rejected Q-Link just based on that dispute. But that dispute was intense. And so it could be understandable why they could read that as a denial on the merits of the application, but it wasn't. My point of that is that other states will read this. California already thought and was prepared to find that Q-Link had already been rejected in New Mexico, when in fact it hadn't. So my point is, again, as you could tell, this will be read perhaps in other states, I think.
Thank you, Anthony. Commissioner Maestas, or do you view those as friendly amendments?
Yeah, I view those as friendly amendments. If Cynthia Howell will give me a second on my motion.
Yes, I will. I most
Mr.
certainly
Chair,
will.
can I just ask Commissioner Hall, because I was typing that down on that second change. Let me tell you what I've written so far. Instead, Q-Link has sought to conceal information as to its adverse regulatory treatment in other states, such as, and then that's where I leave off. Can you just complete that for me again?
Yeah, in other states, specifically California, Texas, Oregon, Kansas, and Illinois, comma, which cast strong doubt on Q-Link's trustworthiness to serve the public interest in compliance with our laws.
Okay, thank you.
And I called it important information that they were trying to conceal, has sought to conceal important information. I think you just said information. But.
Okay, got it.
Okay. Anthony, I saw your hand go up again. Go ahead.
Mr. Chairman, Commissioner Hall, I'm just wondering about the listing of the states.
I wondered that too. That's why I wanted to read it while you're here. If that's too inclusive, if you would take some out, I'm not sure what you think is the best listing of those states.
I'm not sure, and I'll defer to the commission and Russell, but that it's necessary to mention the states there. The record from the recommended decision is clear. So
okay, so we'll take out the specifically clause.
Okay, got it.
Have you got that, Russell?
Yep.
Don't list the states, leave out specifically, and otherwise we're okay.
So what I'd like to do here, rather than vote on the amendment, is Commissioner Maestas, can you move with the edits that were just made, the motion once more, inclusive of the edits, and Commissioner Hall second from there, and we can move forward and vote.
Okay, I'll withdraw my original motion and move to approve my order with the edits provided by Commissioner Hall.
And I'll second that.
And commissioners, any other discussion? Okay, Mike, can you take the roll?
Commissioner Vicente Aguilar,
Aye.
Commissioner Byrd,
Aye.
Commissioner Fishman,
Aye.
Commissioner Maestas,
Aye.
Commissioner Hall.
Aye.
The order passes 5-0.
And I'd like to thank Anthony and Russell. I know for you guys, this was a frustrating one to deal with. And Commissioner Maestas sort of toned down the order, which I think was wise. but I think it was a reflection of just how frustrating this particular case was, and how frustrating it was dealing with this company. So just thank you guys for sticking with it.
Thank you, Mr. Chair, Commissioners.
Okay, so we're on to item number 3, 21 Triple Lot 12 UT in the matter of the formal complaint of James Thomas against Socorro Electric Cooperative. Hans, this one is yours.
Thank you, Chairman Fishman and fellow commissioners. The formal complaint in this matter alleged that the complainant should be credited for any renewable energy credit or REC discrepancies from 2009 to date, and that REC payments should continue in complainant's favor at $5.70 per REC for 2021 and beyond. The formal complaint was filed on January 7th, 2021, and Socorro Electric Cooperative filed their answer on February 2nd, 2021. The Commission issued an order for staff response in this matter on February 24th, and staff responded with their affidavit in response on March 23rd. The complainant previously had reviewed this as an informal complaint and was advised that SEC was within their rights to terminate the contract based upon the contractual language. Complainant indicated that SEC had not provided a REC calculation formula to him, and therefore complainant was unaware if all proper payments had been submitted to him. It is my recommendation that the formal complaint be dismissed with prejudice for lack of probable cause. The SEC indicated that the complainant has received proper payments under the contract, and the SEC terminated the agreement properly as complainant did not agree with a reduced amount of $1 per REC as offered by SEC, and SEC gave notice to terminate in October of 2021. Staff in their responsive affidavit indicated that they calculated what should have been the correct amount of payments received by the complainant, and then compared their work to the discovery provided by SEC for amounts paid that have been paid to complainant, and found that the complainant has received the proper amount of REC payments due to him. Staff further indicated that notice to terminate given by SEC was properly within their contractual rights, and therefore no further obligation exists for SEC to continue making payments to complainant. As such, recommend the formal complaint be dismissed for lack of probable cause, since there is no evidence to suggest that SEC has violated their terms of the REC contract with complainant and have provided proper payments to him, and they were within their contractual rights to terminate the contract under the clause. Appropriate order then has been prepared for your consideration, dismissing the formal complaint, and I'll stand for any questions.
So quickly, Hans, as you were just reading, you'd said that notice was given October 2021. I believe you meant 2020. I want to be sure we don't have a typo there.
That is correct. And there was some slight misunderstanding as to whether or not that was proper notice, but staff did mention there was a typo that had indicated that but complainant did in fact receive his final 3 months of payments. So all payments have been rendered to complainant that should have been for in the time of termination as well.
Commissioner questions? Comments? I will move the order.
Thank you.
I'll second it.
And with lacking discussion, Mike, please take the roll.
Commissioner Maestas,
Aye.
Commissioner Byrd,
Aye.
Commissioner Hall,
Aye.
Commissioner Fishman,
Aye.
Commissioner Vicente Aguilar,
Aye.
The order is adopted by a vote of 5-0.
Okay, we're on to item number 4. Docket 21, 83 UT in the matter of the application of Public Service Company of New Mexico for decertification and abandonment of 114 megawatts of leased Palo Verde nuclear generating station capacity and sale and transfer of related assets for approval to procure new resources under 17.9.551 NMAC. And Michael, please proceed.
Commissioners, this is a proposed initial order that would assign Carolyn Glick as the hearing examiner to handle PNM's application. As you noted, the application seeks approval to decertify and abandon PNM's current leases of 114 megawatts of capacity in Palo Verde Nuclear Generations Unit 1 and 2 under 5 separate leases. 4 of the 5 leases, for a total of 104 megawatts, terminate on January 1st, 2023, and the remaining 10 megawatt lease would terminate on January 15th, 2024, a year later. The approval PNM requests seeks approval to sell and transfer to the Salt River Project Agricultural and Improvement and Power District certain PNM-owned assets and nuclear fuel associated with those leased interests, which are necessary for the ongoing operation and maintenance of the leased interests that are to be abandoned. PNM indicates that the Salt River Project would acquire the leased Palo Verde interests from the lessors, not PNM, upon the termination of the existing leases. PNM also seeks authorization to create regulatory assets for any undepreciated investments associated with the leased interests. PNM would obviously have to seek approval to recover those undepreciated interests in a future rate case. PNM also seeks approval of certain proposed replacement resources, which would be in the form of long-term purchase power agreements. And they also seek approval of requested rate-making treatment pursuant to Commission Rule 551. Those proposed replacement resources consist of a 150 megawatt purchase power agreement for solar energy from the Jicarilla Solar Energy Facility, which would be paired with a battery storage agreement for 40 megawatts of 4-hour energy storage capacity from the energy storage facility, as well as a standalone 100 megawatt energy storage facility of 2-hour energy capacity from the Sandia peak grid. They also seek approval of a 300 megawatt purchase power agreement for solar energy from the Atrisco Solar Facility, which would be paired with an energy storage agreement for 150 megawatts of 4-hour energy storage capacity, also from the associated Atrisco Energy Storage Facility. That capacity is required to ensure system reliability and load needs when 4 of the 5 104 megawatt leases expire in 2023. PNM's application also seeks approval of the application by October 4th, 2021. They argue that the 6-month approval deadline for purchase power agreements under Commission Rule 551 should apply to the entire application. The proposed order for you today would find that, consistent with the Commission's prior rulings, specifically in case 13390, which was a February 11th, 2014 order on completeness, the 6-month time limitation for approval of purchase power agreements under Rule 551 would not apply to PNM's abandonment request, because abandonment applications are not subject to any time limitation under statute or Commission rule. PNM's request for approval of the replacement resource purchase power agreements require that the Commission first approve PNM's request for abandonment of the leased interests. Abandonment of those leased interests is is a prerequisite in order to find that there is a need for those replacement resources. Therefore, any applicable time period should begin to run only after the commission acts on the abandonment request. Indeed, and I point out in the order that PNM's application itself notes that it seeks approval for 2 separate series of actions. The proposed order also notes that because PNM's application seeks approval of not a single resource, not a single resource and purchase power agreement, but multiple purchase power agreements, this may impose sufficient additional burden on the resources of the commission and the parties to justify waiving the time limitations of Rule 551 at some point in the proceeding. However, at this point, the order also recognizes that PNM's request for expediency in order to meet the commercial operation dates in advance of the 2023 summer peak can be balanced and should provide sufficient opportunity for full consideration of PNM's total application. Therefore, the order finds that both the abandonment and purchase power agreements should be addressed in this docket now rather than separating them into separate documents. However, this would be subject to the finding I just stated before that the 6-month time limit of 551, Rule 551 rather, has not been triggered. Finally, the order also requires PNM to file supplemental testimony in this matter addressing issues that had been previously reserved to a further proceeding by the Commission's January 8th, 2020 order on remand in case 15261. That order on remand was issued in response to the New Mexico Supreme Court's opinion in case SC 115, which rejected all the challenges on appeal to the Commission's final order in case 15261 with the single exception of the Commission's remedy, which denied PNM future recovery of nuclear decommissioning costs associated with PNM's repurchase of the 64.1 kilowatt Palo Verde nuclear generating station leases and the 114 kilowatt of renewed Palo Verde generating station leases. The remedy at issue was based on the Commission's ruling, which was upheld on appeal, that PNM had acted imprudently in determining to reacquire and renew those leased Palo Verde nuclear generating station capacity. The Commission's order on remand specifically found, and I'm going to quote it, that the issues of whether the newly acquired and released Palo Verde nuclear generation station capacity has exposed ratepayers to additional financial liability beyond that to which ratepayers would have been exposed had PNM chosen to abandon the leased Palo Verde nuclear generating station capacity and obtain non-nuclear replacement generating capacity, and whether PNM should be denied recovery of such additional amount of future additional decommissioning costs as a remedy for PNM's imprudence established in this case should be addressed in a separate proceeding where additional testimony and evidence may be taken regarding the decommissioning issues and the Commission's proposed remedy of excluding recovery of such additional costs. Given that this application seeks to abandon these leased capacity that's at issue here, this case provides the best opportunity to address those unresolved issues left from that case. So I stand for any questions.
Commissioners. Cynthia, you're, yeah, there you go.
Mr. Chairman, I was just going to say, barring other discussion, I would like to move the order for approval because I think this is a perfect place to include the issues raised by Commissioner, by Hearing Examiner Glick. It's a perfect place to resolve those issues. And this would just be a good thing to do. And I don't mind, well, I guess we're not imposing the 6-month time limitation on us, so I don't mind it even better. So I think, so I'll move the order.
I will second. Is there any further commissioner discussion?
No.
Well, there you got the definitive answer from Commissioner Byrd. Mike, you better take it. Mike, please call the roll.
Sorry about that. I managed to hit a key that muted me. Commissioner Fishman,
Aye.
Commissioner Byrd,
Aye.
Commissioner Hall,
Aye.
Commissioner Bisseni Aguilar,
Aye.
Commissioner Maestas.
Aye.
The order passes 5-0.
Okay. Thank you, Mike. We're on to discussion items number 5. This is regarding tracking compliance with commission orders. And this is a follow-up to last week's discussion where it was pointed out we didn't seem to have a record of what had gone on in terms of follow-up on some commission orders that came out of a rate case. We've had some clarifications since then, but Commissioner Maestas had rightfully, I believe, raised the issue of, gee, what are we doing to be sure we're keeping track of this? When we have commission orders coming out of the docket that require follow-through, do we have some sort of log? Do we have some sort of tracking to be sure that we've actually followed up? And, you know, how many of these issues are hanging out there? Subsequent to last week's meeting, I had a discussion with Mike, and yeah, my thought in talking with Mike was that, hey, the best way to do this is not for the commission to try and invent a log, but to have Mike get together with Wayne and whoever else he needs to, and come up with a proposal. And my suggestion on that would be that you know, you check that out with each of the commissioners to be sure that we're addressing exactly what their concerns are and what they need to see in how this kind of follow-up log might look and what would be included. So what I wanted to do was just formally let the commission know we'd had that discussion, but then to get your comments if you feel comfortable that that's the right way to proceed. And perhaps we could set a date that we want to see an example of what that report might look like. So with that, I'll open it up for other commissioners to throw in their 2 cents.
Mr. Chair?
Yes, Commissioner
Mr. Chair.
Maestas.
Yeah, thank you. You know, I raised the issue last week because of several examples of, I think, you know, possible oversights in tracking commission orders. You know, one was the staff testimony in the Avangrid PNM merger regarding the 2 wind projects by Avangrid. I think one of them was supposed to file construction permits, and I think that's been rectified. I think they've been filed. But there was also another one regarding El Cabo wind farm. And then, as you alluded to, the time of use rate mediation for PNM. And so I think these are just a few examples of compliance that we need to be tracking. And my hope is that I see it as an administrative tracking exercise that perhaps can be done under ASD. And then if there are any deliverables associated with those compliance or those commission orders, there needs to be some kind of a review and acceptance by appropriate staff, and then to close the loop, an assurance that those deliverables and those requirements are acceptable to staff. And I think that the commission needs to be notified, and the record is closed, but the compliance is closed. So I see this as kind of involving several, I think parts of our organization. So I see administration, I see potential OGC coordination with utility division, and then a notification to the commission. And I'd like to see, some kind of tracking system that's robust, so that nothing falls through the cracks. And so that's my expectation, Mr. Chair. And I'm sure there's a process in there, but I think in order for us to improve the process and prevent some of these compliance issues from falling through the cracks, it'd be good to at least find out, which is what I requested, find out what we're doing today. So with that's just my initial comments, Mr. Chair. I'm multitasking. I'm listening in. I'm zooming on the NARUC new commission orientation and listening on the phone. So bear with me.
Okay. So really, Mike, for you and Wayne and John and whoever else looks at this, that's I think the guidance that Commissioner Maestas just gave is very much in sync with certainly my thinking. Other commissioners, do you have thoughts on this? Commissioner Hall?
Yeah, Mr. Chair, oh, here, it's the right button. I think it's a great idea. I don't know why we didn't think of it before. We need to do this. I'm in complete support.
Other commissioners, any particular comments? So my question to Wayne and to Mike is, could we have some kind of proposal together within the next month or so?
I guess, Mr. Chairman, I'll respond. I think, part of the reason when we had this come up last week, Commissioner Vicente Aguilar raised the issue of that this is something that really should be gone over with the Chief of Staff, and I agree with that. And I've spoken with John Reynolds a few times about this since then. I think there's some big issues that sort of need to be addressed in terms of how we address this. I'm not sure whether I can commit that a month, I certainly would hope we could come up with some sort of response in a month. But there are some sort of big organizational issues, I guess, in terms of what a fully comprehensive compliance idea of ensuring compliance constitutes. One thing John had pointed out to me is that sort of apropos of what Commissioner Hall just raised is that there used to be a compliance bureau, and at some point it sort of dissolved over time. And I had noted that in one of the previous pieces of legislation that had been pending, I think it was House Bill 11 2 years ago, one of the proposed positions that would have been, or several positions I think that were proposed to be funded with the commission were for compliance personnel. And I think, so I think we need to have a discussion about, how this all sort of gets divvied up in terms of, technical compliance issues, the compliance at the level of the adjudications. There are a variety of different issues that sort of need to be addressed. And I think certainly welcome commissioners to be part of that discussion that we have with the Chief of Staff. But I think we'll have to meet and talk about this and figure out where this goes.
And my thought on this is that there's kind of two stages. One is kind of the short term, which is where we take a look at where particular orders have come out of a docket, and we just want to follow up on those particular orders. But then there's the more robust concept that you're bringing up, or at least in my mind more robust, Mike, is the compliance writ large, and whether we, should get back to having compliance positions on staff. So I do think it's appropriate as you have those discussions to look at kind of the short-term, less complete solution, and certainly make recommendations for longer-term solutions that might involve additional resources.
Mr. Chairman, Commissioner, I totally agree with you. And I was actually going to bring up in this discussion today that, I mean, my immediate Band-Aid sort of response to that is one thing that we can do to address the issue immediately is to, I guess, change our, or I guess add provisions, I should say, to our final orders that require the filing of compliance orders on a number of things that in our orders previously, there were no requirements for the filing of, of follow-up filings by the affected utility. That's the subject of the final order. So, things like we have, just sort of going back to that 15261 case that we were talking about, there were a number of, 16276 case rather, that we were talking about with regard to the time of use rates. There were a number of other issues in terms of requiring the parties being required to get together and confer on various matters, but there were no requirements in there that, that there was kind of a compliance filing stating that, we have done these, held these required conferences and the results were, whatever. As I said before, we can't really require when we're requiring them to confer to actually, come up with an agreement. We can't require them to agree in advance of a future case, but that was not really the intent. But at least we could insert in our future final orders provisions that require them to make filings confirming that they have actually performed those tasks. Other requirements we track at OGC more at the adjudicative level of, legal proceedings. So, to the extent that there were requirements in that order that they perform a cost benefit analysis as part of their upcoming 2020 IRP plan, we were able to confirm that that was done when the IRP plan is filed. Similarly, there was a requirement that a new docket would be opened to address energy efficiency disincentive measures, and that did result in a case that was filed within 30 days of the entry of the final order in 16276, and ultimately that case was dismissed. But those kind of things OGC is able to track pretty readily. But it's the sort of more nebulous things that we don't have those requirements that they make compliance filings that I think we can address by, inserting requirements in the final order that they do so.
And I will say that from my perspective is if we have kind of a log of items to be followed up on from various dockets, from a commissioner standpoint, it helps me keep a better focus on the big picture of what's going on. But I'm just speaking for myself there. I'm not sure how other commissioners feel about that.
Mr. Chair, this is Commissioner Maestas.
Go ahead.
Yeah, I just to this point, I think we should probably revisit the format of our orders, because it's very difficult to find some of these compliance requirements that live beyond the effective date of the order. And even if it's a restatement of some of the follow-up compliance requirements that are in the therefore part of the order, but I think that we should at least look at the format of our orders that have follow-up compliance issues. And then I guess just maybe a note to ourselves, certainly a note to myself, is that whenever we do have any follow-up compliance requirements, that we be as explicit as possible.
Yep.
And not add to any ambiguity with respect to some of these compliance requirements. So that would be my two initial observations and recommendations.
Yeah, and I would imagine, and then I'll get to you in just a second, Commissioner Hall. I would imagine that in the decretal paragraphs, did I pronounce that correctly? That we can, add that specificity and kind of close the loop a little better than maybe we have in the past. So anyway, and so I think that's a good suggestion, Mike. Cynthia, Commissioner Hall, go ahead.
Yeah, and I just wanted to concur. I think what Mike describes will go a long way, maybe all the way to what we need. But and if there's formatting improvement that can be made, I think we should work on it. But definitely, I look to the decretal paragraphs to see what they contain, because that's all we've ordered. And if we haven't ordered everything in it, then that's on us. So that's a good place to start right there.
So Mike, do we feel any, asking for something a month from now, but we could put it on the calendar for the commission meeting a month from now for follow-up discussion and see what you got then? And Wayne, please feel free to jump in on this one if you've got any thoughts. I think that would be very helpful to the commission. And we're not asking for the huge permanent solution or looking at staff. It's just the short-term solution, the Band-Aid, as you described it, that we would be asking to discuss and hopefully have some temporary solutions then.
Mr. Chairman, I don't see any reason why we can't have something to you within that time frame. So we'll get to work on it.
Okay, thank you, Wayne. And Isaac, please put that in your notes to get on the agenda 4 weeks from now.
Mr. Chairman, Commissioner, I'm just going to just give you a heads up. I'm actually going to be out of town the week. That's first time I'm practically leaving my house in a year and a half, but I'm going to my son's college graduation that week.
Wow, congrats.
Oh, cool.
Thanks. So 4 weeks, unfortunately, exactly falls at a bad time for me. So either a week ahead or a week after, I should be fine.
Okay, so let's go a week ahead. We'll do it in 3 weeks. And then you won't have that weighing on your mind when you go to your son's graduation.
Thanks.
Mr. Chairman?
Yes, Commissioner Vicente Aguilar.
I would also like to make a note that Wayne, our new chief of staff, is going to be out of the country as well. So I think this is a huge request from the commissioners. I would suggest that we get a report back until probably, I think we need to extend the time because I did hear from the chief of staff that he has a pre-commitment for plans. That's just my take on it. Thank you, Mr. Chair.
Okay. Wayne, thoughts?
Mr. Chairman, how about I know this is a little longer than you want to go, but in light of both my commitment and Mike's, could we try to have something to you by June 9th?
Sure.
I know that's a little bit longer than you like, Mr. Chairman. I apologize for that. The other option would be May 12th. I'm not sure if that's the week Mike's gone or not. It seems like it might be the week after that, but Those would be the two I would suggest. And Mike, if you think we can get something by May 12th, maybe we should shoot for that.
This is Michael Smith. I'm fine to work on it. I mean, we can try to get what we can. I think from our perspective, there's the issues I just raised, but I think we've got, in terms of what Commissioner Maestas was raising and beyond the things that are required to be filed in cases and things of that nature, to the extent that we're talking about follow-up on what the utility is doing in compliance with all the aspects of commission orders. That might be a larger discussion. So
Michael, you think we could at least come back with what we've been thinking about and talking about by May 12th?
Oh yeah, absolutely.
Let's do that, Mr. Chairman, May 12th, if that works for you.
Okay. Thank you, Wayne. Really appreciate it. And, that May 12th might just be a check-in discussion to be sure we're headed the right direction. And that, I think, would be really helpful. So thank you. Any other discussion on that item? Okay, with that, we'll go to communications with Chief of Staff. First time.
I'm still getting used to that, Mr. Chairman. Good morning once again, Mr. Chairman, members of the commission. It really is an honor to be here, 2.5 days into my tenure with the commission. It feels already like home, and that's partially not only because of the warm welcome that I've received from the commission, but also the warm welcome I've received from your staff, the assistance I've received from them, particularly Jason has been absolutely wonderful. But all of the staff that I've had a chance to interact with have been great. So very happy to be here. I hope I've jumped in with both legs and arms and everything else starting this past Monday. I don't have a whole lot, not surprisingly, after only 2.5 days, Mr. Chairman, but I did send an update to you yesterday after our tour of our new office space, and I'm happy to answer any questions that update may have created. Beginning tomorrow morning, I'll be pretty busy all day tomorrow and most of the day Friday with back-to-back meetings with division directors. And I'm also hoping, Mr. Chairman, I believe I mentioned this in a previous communication with the commission, that at some point, maybe as early as next week, I'd like to schedule some time with each of you to just get your thoughts on the direction of the agency, what my priorities should be, and just have a bit of a time with each of you one-on-one if your schedules permit. We have a couple of deadlines coming up. Our FY22 operating budget is due to the LFC and DFA on May 1st. Our ASD department, Jim and Annette are hard at work preparing that. I think it's pretty much wrapped up, but we'll give a report to the commission on our operating budget at next week's meeting. Also, we are trying to wrap up our annual employee evaluations. Part of House Bill 2, the General Appropriations Act for FY22, included a 1.5%, what I refer to as a cost of living adjustment for all state employees. In order for employees to receive that 1.5%, though, Mr. Chairman, they need to have completed annual evaluations. So that's always a bit of a crunch deadline for any state agency, but Renee in HR and her staff, Denise, are also working very hard to make sure that we have our employee evaluations up to date. So with that, Mr. Chairman, I know it's been a long morning for you already. I know Commissioner Maestas is doing double duty, so I'll stop there and happy to answer any questions or receive further direction from the commission.
Commissioners, any thoughts? Okay.
Nope.
Well, thank you, Wayne. It's a pleasure to have you aboard, and thank you for that nice, concise overview of what's going on. Really appreciate it.
I'll try to keep it that way.
Mr. Chair, excuse me, Mr. Chair. I was muted and I couldn't get myself unmuted fast enough, but I just wanted to say I really appreciate the efforts our new chief of staff is making to get to know division directors, commissioners, everybody. I think we're off to a really good start, and I'm just appreciative of what sounds like a real thorough and connected approach to the job.
Okay.
Thank you.
With that, we're going to move on to communications with general counsel.
Mr. Chairman, I've got one thing. I think Russell has one thing. I just wanted to address and clarify, because I sensed Commissioner Byrd was about to say something when we were voting to ratify the prior vote on April 14th, 2021 of the emergency order granting temporary authority to provide ambulance service to Tucumcari ambulance service. That the action we took that day was not actually in violation of the Open Meeting Act. It was an emergency action that's deviation from the Open Meetings Act, and we do the ratification even though it's not technically required, at least according to the manual that the Attorney General has put out. We do it to provide the opportunity that if there was somebody who would have, made public comment or done something else of that nature, that they have that opportunity, and so that we do, put it back on the agenda, address it the way that the Open Meeting Act normally contemplates that it would be done. And I think Russell has something that he would like to address.
Yes, Mr. Chair.
Thanks, Mike.
Oh, sorry. Yes, Mr. Chair, Commissioners. This regards the Q-Link matter, and if Michael can tell me afterward, tell us afterward if we need to recall the matter and for vote. It's a very minor issue, but it's important, and because the Commission adopted very specific language as per Commissioner Hall's amendment, I just wanted to pass it by the Commission before making any such change. In the paragraph 4 at the end, where the amended language would refer to concealment of important information, which casts strong doubt on Q-Link's trustworthiness. The language says, which casts strong doubt on Q-Link's trustworthiness to serve the public interest in compliance with our laws. That's the language that Commissioner Hall recommended. I want to change it to in compliance with applicable law. The reason that's important is that any court would understand the words "our laws" to refer to state laws. And as you know, this is one of those instances in which the Commission is actually applying federal law, including the federal standard of public interest for ETC designation. So I want to make that change so it's clear that we're not referring to state law there, but to the applicable law, which is federal law. It is important in this case, and I wish I had caught that during the matter. I don't know if Michael, do we need to recall the matter for that, or?
I think that's consistent with what Commissioner Hall's intent was, and I think
yes,
if commissioners have believe that that's not consistent with the intended scope of what Commissioner Hall's modification was, then we can take a revote. But
Mike, excuse me for interrupting, but it's completely consistent with my intent. I think it's an improvement. It's much clearer, and I appreciate Russell bringing it up. I completely concur and adopt that language as my own.
Okay, thank you, Mr. Chair, Commissioners.
Thank you, Russell.
Okay.
Okay, Mike, anything else?
Nothing further.
Okay, thank you. So we're on to communications with commissioners.
Mr. Chair.
Sure, go ahead. I think that's Commissioner Maestas.
Yes. Sorry, if I may go first. I just have a few things to cover before I sign off. On Monday, April 19th, I issued a bench request asking for additional information on arrearages for small utilities and co-ops, and calling for a workshop on April 29th. The reason is, as you know, our January 3rd order regarding a moratorium on disconnections has a date of May the 5th where the moratorium would expire. And my intent of issuing the bench request is to get a sense of how co-ops and small utilities are doing in working out utility plans, repayment plans for their customers, particularly those that are facing disconnection. And the workshop is just intended to get feedback from them in terms of what changes they can perhaps make in their own administrative policies. For example, how many arrearages would trigger disconnection? What other measures can they take beyond a repayment plan? Should the commission revisit the order? And just in conclusion, I think it's really meant to show New Mexicans that the Public Regulation Commission is very concerned about this looming date of May the 5th. And I believe it's incumbent upon us to monitor this situation leading up to it. Now, I will say that in our original order, we did ask for federal aid, any state and federal aid that utilities are receiving, and the co-ops are not reporting that. And so I'm emphasizing that. I emphasize that in my bench request that they need to send this information so we can get a sense of how the federal and state money is being allocated, how it's starting to get out there and alleviate the financial pressures of utility customers. And so, and perhaps we need to consider that. Perhaps there should be maybe more time needed for this aid to be allocated to these customers. I realize the emergency rental assistance only applies to renters, but so I just feel like we should create a dashboard leading up to May the 5th just to see how things are going. And I guess in closing on this issue, I think I alluded to this last week, how P&M is hiring a consultant to man their call center to prepare for their deadline for the expiration of the moratorium for the investor-owned utilities, which isn't until later in the summer. And so I think we should be prepared as well as a commission. So that's the reason for the bench request, and I invite my colleagues to attend the workshop. My other issue is, as you know, several weeks ago, we, as a commission, developed a selection process to select the next Transportation Division Director, because at the time our Chief of Staff was acting Transportation Division Director and Bureau Chief with Pipeline Safety, and Pipeline Safety reports to the Transportation Division Director. So Commissioner Byrd and I had been selected by you all to oversee the selection process. We had some milestones that existed in the process that we laid out. We were scheduled to complete interviews of shortlisted candidates that meet minimum qualifications by April 30th, and wanted to have the position filled by June 1. But with Wayne here as our Chief of Staff, should that task be handed back to him, I recommend that we do. And I think that perhaps at the next meeting, if that's necessary, to make that decision, since we made the decision in the form of a formal action to create this special selection process for the Transportation Division Director position. And so I suggest, Mr. Chair and members of the Commission, that we have Wayne take over, but I'm just wondering, should we make it more official and have it come before the Commission that we withdraw the selection process because of the changed circumstances and delegate that as we should to our new Chief of Staff. That's all I had, Mr. Chair.
Thank you. Just quickly, Commissioner Byrd, Do you concur with Commissioner Maestas on this?
I do.
Okay. And speaking for myself, I believe it's, in terms of staff, it's Wayne's show now, and I think that's absolutely the right direction to go. So, Mike, do we need to take any formal action to do this? Or can we just pass it on to Wayne?
Mr. Chairman, I believe the commission can just pass that on to the chief of staff. That's his normal function anyway.
Commissioners Hall and Vicente Aguilar, does this make sense to you?
Mr. Chair, I'm fine with it. I think it's the appropriate thing to do. Assuming we didn't vote on assigning them that task. I don't think we did, but if we did, we might have to re-vote. But I don't remember whether we did that. I doubt it.
I don't think we did.
Okay. Okay.
And it's fine with me, Mr. Chairman.
Okay, terrific. So we've put that into the right court going forward. Thanks, Commissioner Maestas and Commissioner Byrd, for volunteering to take care of that. Any other commissioner comments?
Mr. Chairman?
Yes, Commissioner Vicente Aguilar.
Yes, Mr. Chairman, I just want to welcome Wayne as our new Chief of Staff. He will learn how each commissioner's their style of doing their work. And from my point of view, feel free to contact me away from the open meeting if you have a question. And in return, I do the same. I will call you if I need assistance or if I need additional information. And welcome to our family. We've been, as you know, we've been working remotely. It's been challenging, but I guess the decision makers, they wanted us to feel the challenge. And I always say, it's okay with me. And I normally just call in for the open meetings. And I just wanted to say welcome, Wayne, as our new Chief of Staff. A first meeting is always special. First of everything is always special. And that's my acknowledgement. So welcome to the family. Thank you.
Thank you, Mr. Chairman, and thank you, Commissioner. That means a great deal to me. And you're right, this is a day and a meeting I won't ever forget. It is very special, and thank you again.
Commissioner Maestas, I wanted to just follow up with a question. Are you still on?
Yes, Mr. Chair, I'm still on.
And I know we had talked and you'd mentioned that you and Jonas have wanted to tackle in particular the rule for community solar. And I just wanted to find out if you had any particular thoughts you wanted to tell the commissioners on that.
Well, yes, thank you, Mr. Chair. As many of you know, the community solar bill did pass, and it did give us a mandate to develop a rule by April 1st of 2022. And as you know, Jonas and I were looking at procurement options to obtain outside professional services to assist us with rulemakings, not just new rulemakings, but updated, rulemakings. We were pursuing decoupling, but as you know, as we all know, that decoupling issue right now is pending the outcome of a case where we'll be developing a declaratory order to address key legal threshold questions. And so now that this bill has been signed, oh, and then we were also looking at transportation electrification, but we already have plans. We have 3 cases where transportation electrification plans are being reviewed. So I think we have some time there in transportation electrification. So community solar has come to the top because of that legislative mandate. And the effort has a lot of momentum coming off the community solar working group that convened since the 2020 session, and they've rendered a report. Many of the recommendations have actually made it into the final legislation, but there's yet a lot of issues that need to be resolved. And I think the sooner we get going, the better. And so Jonas and I are very close to finalizing the scope for a professional services contract to assist the PRC with the rulemaking. We have enlisted the help of Arthur O'Donnell, who's been invaluable in assisting us, and we intend to circulate the scope to all the commissioners as well, because we want to make sure that it is inclusive of all the outstanding issues that need to be addressed during the course of the rulemaking. So this is a big deal for us, and I want to make sure the commission meets that legislative deadline for the rulemaking for community solar.
So my thought is this is there's a lot of moving parts in this rulemaking, a lot of things to consider. So it's a good chunk of work, and I'm very comfortable with Commissioner Maestas and Jonas taking the lead in helping pull this together. So I just wanted to be sure all commissioners were aware of what's going on there.
And Mr. Chair, if I may, I wanted just to make one statement about potential additional funding for us going forward. As some of you may know, there was a sentence in there in the appropriation bill that was passed that would provide a loan to the Public Regulation Commission for the implementation of many of the pieces of legislation that we had indicated that were unfunded mandates during the course of this last session. And so we're trying to get a clarification with Department of Finance and Administration and ask them, is this a loan or a grant? How is this going to work? But this could be critical for us going forward to implement a lot of these pieces of legislation that require an extensive amount of work from the commission, from commission staff. So we are working with that. ASD and Jim and Annette are working tirelessly with DFA to really get a clarification on that, because I think it's very, very important. Tongue in cheek, maybe we can repay the state back with the revenues that we collect on its behalf. Just a thought.
That's not
That's all I had, Mr.
for
Chair.
me. That's not tongue in cheek for me. We all know how that should go. We just can't convince the legislature to do it.
So, Mr. Chair,
Commissioner Hall.
I wanted to mention that tomorrow at 9:30, going till 2 o'clock, there will be another technical session of the interconnection rule working group that's been established in connection with our inquiry proceeding associated with our desire to develop an interconnection rule and, well, not a rule, amendments to the rule and amendments to the manual. And it's going to be an interesting meeting, I think. Well, they're all interesting, but this one is going to be chock full of information for those of you who are interested in hearing what companies in the state are doing with respect to these interconnections. If you're district is affected and you want to understand what their current practice is, and this might be a good one to sit on and listen to. But in particular, I noticed in the afternoon, there's a commenter, someone who's going to be speaking, not just commenting, providing a 15 minutes. There are a series of speakers, actually, I should say, someone from, and they're all about 15 or 20 minutes. There's someone from EPRI, someone from Sunrun, someone from XL, someone from WRA, and then the three investor-owned utilities in the morning still, SPS, PNM, and EPE. Then we have a break at lunch for 10 minutes. And then we go on with some comments from the co-ops. And then we have two presentations. One is by an interconnection expert from Sandia Labs. But what I'm getting at is the other presentation is by Kevin Craig from the Community Solar Association. And he's going to be talking about considerations of interconnections for community solar. So, you know, that might be something that Commissioner Maestas or Jonas might be interested in sitting in on. That doesn't start until 12:55, according to our agenda. And it makes me reflect on a thought I'd had in the past, which is a number of our proposed rules that we're working on have a little bit of overlap, and we definitely want to make sure that they're consistent with each other. And I think in our going forward and developing these rules, we need to be alert to that. And I certainly, you know, when I become aware of something in the interconnection rule, I'm going to try to be real diligent to share that information. And, you know, I'm sure we'll get alerted to by general counsel attorneys who are helping us to some degree, but I think it's an issue we need to make sure we're alert to just make sure that, you know, the rules we're developing all kind of make sense together as well. But in any case, I'd like to invite anybody who's interested, except I guess we can't have too many commissioners because well, I don't know. I would like to ask Isaac, if he's on, if he issued a notice of possible quorum, because sometimes commissioners want to get on and listen to these meetings. It might be a good practice to do for these meetings as they continue. We'll have, I think we'll have 5 more, well, 4 more after tomorrow. So in any case, please come unless we haven't noticed a possible quorum.
Paul and Chair Fishman, may I interject for a minute?
I can't hear you, Colin. Can you speak up?
There you go.
Yes, can I just wanted to interject to say that Isaac did issue a notice of possible quorum
Oh,
for
great.
tomorrow.
Super. Thank you, Colin. So definitely, Commissioner Maestas, if you or Jonas are interested, that might be a good time to pop in just to hear whatever Mr. Cray is going to be saying about the interconnection rule vis-a-vis the community solar bill.
Thank you.
Real quickly, there's, I believe, over 60 registered participants in these meetings. They've been really well attended, and I wanted to thank Commissioner Hall for the great work she's doing getting this interconnection off the ground. And also kudos to Arthur O'Donnell. If you've checked in and listened to any part of the meeting, he runs a tight ship, and thanks to Art for, you know, providing his support there. And just thank you. It's really worthwhile and good stuff.
I just got, Mr. Chair, I just got a text from Colin also saying that the Sandia Labs guy is not going to be presenting tomorrow. It got pushed back because it's such a full agenda. So he'll be presenting a different time, but the community solar guy will definitely be there. So,
yeah.
But I totally agree. I really appreciate Art's wonderful professionalism in running these meetings, and he's quite an adjunct to our efforts here at the commission. And I appreciate everybody's hard work on this rule and then also on the integrated resource plan rule.
It's tough when you have 60 people on keeping order when you're going through.
They've been wonderfully attended too, and I'm impressed with the the level of interest by the solar community, and especially, I'm really grateful for the number of engineers who really have the expertise to apply. I mean, they routinely have had 65 people to commence with in the morning. It kind of dwindles down into the high 40s by the afternoon. But we've had very good attendance, and I'm hopeful that we'll get a really good product out of this effort.
Other commissioner comments, communications.
Mr. Chair.
Commissioner Byrd.
Thank you. I just wanted to give you guys a little bit of update of what's going on with SPP. As you guys can imagine, most of the discussions have been centered around that event that occurred back in February. We have our second quarterly meeting on Monday, which goes on all day. And a lot of the discussion there will still be about that event. So we're beating that horse pretty good. I'm also now on a second subcommittee that will be looking into the generation tie lines between the West Coast grid and the East Coast grid. Initially, we're going to be looking at who should be paying for the upkeep and maintenance when they use those systems. But the next portion of that will be, are they adequate? Do they need to be upgraded or maybe even more units put in? But anyway, initially we're going to be looking at who's paying for it, the usage of them and things like that, and what's an appropriate fee. And that affects us here in New Mexico. So anyway, I am one of the commissioners from the RSC, Regional State Committee, that will be on the subcommittee looking at the gen tie systems. And we'll be starting meetings on that as well here pretty soon. The first meeting actually hadn't been set, but they wanted it done by, I think, in May. We'll start our first meeting on that. And then that'll be probably at least monthly, if not bi-monthly meetings for a while. Anyway, I just want to give you guys an update what's going on at SPP from my world. Thanks.
Mr. Chair?
Commissioner Hall.
Well, I'd like to ask a question about that. That's very interesting. You're talking about the existing gen ties, right, in New Mexico and Colorado?
Yes,
isn't that where they're located?
right.
So is this an anticipation of possibly beefing them up so there'd be better transmission, I guess, between the east and the west interconnects, right?
So initially, we're going to look at who should pay the fee for usage, right? Who's using the highway and what's the appropriate fee. So that's what we're going to be focusing on initially. But as they start being used more, it was a very important part of this event in February. They were using them to the max, all the power they could get from the West Coast, because they weren't experiencing that weather event. That we could push through those tie lines was being used. Anyway, so first it's who pays for it, and let's get that figured out. And then down the road, they expect to see what's an appropriate build out, and then who will pay for that. If you build more of them, somebody's got to pay for it. And SPP is all about, keeping the cost down, but also shared costs, because we all benefit from these generation lines, some days more than others, but we're all benefiting. And so there's an appropriate fee that goes along with it. And that's kind of what a SPP looks at. RSC specifically, that is our mandate, is to make sure that allocated costs are appropriate. I hope that answered your question.
Yeah, it does. Well, my reason for the question is, there have been some discussion about those interconnects before in the past, and what I had understood was they weren't really very large. I mean, they weren't big enough, let's say, to accommodate the amount of traffic that really could go there if we wanted to do a lot more east-west transmission. So that was why I was just wondering if they're already planning on building them out. But I hear what you say; they need to go in steps. first figure out who's going to pay,
Right.
pay for the usage now. But I think I'm hearing, I guess I didn't hear you say they're going to be looking at building them out to be bigger or more of them yet, right?
That's on this committee would be looking at that. That's kind of
Later
step
on.
2.
Okay.
Once we figure out who's going to pay for the usage and what's an appropriate fee, then are they adequate and what changes would need to be made and who pays for that? So it's of course like anything we deal with, right? It takes time. So we hadn't even done the initial meeting yet. I know that Commissioner Dennis Grennan is the other commissioner. There's going to be members from COG, SPP, staff have been appointed to this committee, and 2 RSC commissioners, which is the appointed elected commissioners from states, Dennis Grennan and myself.
Great. Have fun.
So that's exciting and put me down as someone who's very interested in exploring additional transmission capabilities between the western and eastern grids. So certainly important.
Well, as we saw during that event, they were still having wind and solar on the west side, and here in the central side in the SPP footprint, basically wind and solar was non-existent. And so they had power. We didn't have any, push all they could through. But when it's windy in Kansas, sometimes it's calm in Colorado or Arizona. And so power will be cheap on the eastern grid, and higher in the western grid, and we can push through and sell power that direction. And that's kind of what we're looking at right now, just the day-to-day usage. As cold fronts and fronts in general move through, the weather pattern changes from one side to the other. And so one side will have an abundance of electricity while the other has a shortage, and vice versa. And we're going to be using those DC ties kind of more regularly than we had when you have firm power generation, where everybody knows what they're getting and they got what they got. So anyway, that was longer than I intended to take.
Yeah. I think it's an exciting thing, and I've seen various articles discussing about whether or not it makes sense to even have regional transmission organizations in the future, because we're going to need to be transmitting electricity nationwide if we're going to have more adverse weather events like this or worse ones. But I would note, my understanding was that in Iowa, the wind energy kept generating because they had weatherized their equipment properly. So I guess it depends on the severity of the weather, but it's nice to be able to have the ability to transmit what you need from east to west and vice versa when you need to.
Okay.
Right.
Yeah.
Other commissioner communications. I'll jump in with a couple here. Regarding the procurement and IRP rule, just as a quick progress update, and Cynthia's been Commissioner Hall's really done most of the work on this. I've done more monitoring, but since she didn't cover it, I'll
I forgot to mention it. Go ahead. That's
add to my
fine.
comments if you need to, Commissioner Hall, is that we've got Colin Gillespie, Commissioner Hall's assistant, and Robert Lundeen, my assistant, currently going through the rule. A lot of the details are there, and now it's just kind of streamlining it and packaging it so it's a clean, well understood document. And so Robert and Colin are going through that right now, and we should have something in not too long that everybody can look at and that is nice and clean and make sense to everybody about what it does and why it's important. So that's exciting and good to see. Cynthia, go ahead and jump in on that.
Oh, I was just going to say, I spoke to Colin before the meeting and he said they worked a long time on it yesterday and they pretty much think it's, it's all in the right order. So I'm going to be looking at it probably this afternoon and we'll ship it on to you. I think they had a few more little details they wanted to look at, so I don't want to promise it, for today or tomorrow. I don't know. I'll have to consult with them, but I think if it's not, I'm hoping it'll be ready for next week. But what needs to happen between now and then is to clean up the final little tiny details and then get it put together in the exact format that General Counsel's office would have to put it in order to send it to the records office or whoever handles it to issue as a NOPR. So, but Judy tells me that she could do that in a day or two. So if things go quickly in the next week, we might have it on the agenda. If they don't, it'll be on the agenda for the following week. Yeah, we're really, really close. And it's been a real challenge, but a very interesting and good one. And I think we're starting out with a good NOPR. I mean, with all this work, we're definitely going to have comments, I'm sure, and we'll still have to hash through more stuff once we issue a NOPR. But nevertheless, I think it's got all the elements that we were concerned about in it. So.
And just to remind everybody, we've seen it in recent dockets, is that there have been disputes about RFPs and how they were handled and what the process was and were they fair, and that's been kind of an ongoing theme. And this rule is intended to address a lot of those issues. So to me, it just feels very timely and germane.
Agreed.
Are there any other, well, let me see, did I have any other comments? I also wanted to follow up on, on the issue of 440 investments, Rule 440. And, if you look at the last couple of years, we've had somewhere in the order of $250 million of notices of investment by utilities under Rule 440. One of the latest ones was the $34 million for the Arroyo project substation and switching station, I guess. And so those are some big numbers. And certainly, I'm planning to take a closer look at that because, quite frankly, the substation and distribution investments, if you look at utility plans, they're planning to do more and more work in those areas and have more investments as we do grid modernization. And I think it's important we start to get a handle on those investments in an administratively streamlined manner. Personally, I'm going to keep taking a look at that, and I know Commissioner Maestas is interested in that. And I'm going to ask Robert to work with me and develop some more ideas around that and kind of float them around to the commission and get a sense of what we might do in that whole sphere, because those numbers are big. And right now, we're not really looking at them very closely. So just an update to the commission that I'm looking into that. What we're going to do with it or what we might propose, I don't know yet. But
Mr. Chair,
that's pretty much that. Yeah, Commissioner Maestas.
No, I just wanted to add what you stated about the Rule 440. Our two assistants are working together to see, where we can perhaps improve the 440 rule. Obviously, there are ties to location approval, which is a statute, but I think there's a lot of room for improvement. We're going to be seeing new projects that are going to look very different from past projects like the Arroyo project. That's going to have a wide variety of components to it. And we need to make sure that for these, particularly these new projects, that they don't get piecemealed and parsed out through 440s at the expense of the intent of the location approval statute and rule, number one. Number two, I think we're going to be seeing many renewable projects that are going to fall within this area being under 300 megawatts, which is the trigger for location approval. And now with the community solar that requires us to develop siting guidelines for the community solar projects, which are capped at 5 megawatts. And so there's a big gaping hole there, a donut hole. And so I think, what do we do? Do we just leave it like that? Or do we look at some of the trends in terms of nameplate capacity of some of these PPA projects that come before us? So anyway, I think this opens up a lot of issues, and I think it's the right time for you, Mr. Chair, with the help of other commissioners, to really look at the 440 rule and see how we can improve it going forward.
And I should point out also from the financial standpoint, when we're evaluating these projects, when they get piecemealed, perhaps our financial analysis isn't as complete as it should be. When we're looking at these as PPAs or CCNs, and it's an opportunity to look at that as well in the way that we operate the 440 rule. So it touches on a whole bunch of stuff. And it even touches on, quite frankly, the IRP, where in the rule there'll be a couple of lines that address this issue and at least open up the IRP to considering some of the interrelationships more thoroughly than they have in the past. So getting the 440 right, I think we'll see has a lot of tendrils. And I'm happy to be having Robert and Jonas and their energy helping us work on that.
Yeah. Mr. Chair, we do have reference to the distribution system in the IRP procurement rule. So that encompasses it. So, but I think we need to look at the rule, at the 440 rule as well, to see what else pops up.
Okay. Any other commissioner comments at this point? All right, we talked a lot, and I think we're ready for an adjournment. Thank you all for a good meeting.